The Second Division of the Commission on Elections has dismissed the disqualification case refiled against Senator-elect Erwin Tulfo. The first disqualification case filed by petitioners was dismissed due to failure of providing proof of service of the petition with complete annexes to the respondent. The order on the original petition was released last March 11, while the refiled petition was submitted last March 27 by disbarred lawyer Berteni Catalunya Cosing and Graft Free Philippine Foundation represented by Justado Villar Calonge. Based on the resolution, the Comelec Second Division emphasized that the petitioners improperly combined into a single petition the separate grounds for Tulfo's disqualification and cancellation of a certificate of candidacy. According to the resolution, the petitioners filed last March 31 a manifestation and motion to adopt the integral parts of the refiled petition, including the certified copies of annexes of the original petition for disqualification. The petitioners then sought to disqualify Tulfo from the 2025 midterm elections due to his citizenship, alleged violations of the Equal Access Clause, and political dynasty prohibition and academic qualifications. The Comelec Second Division said that the issues raised by the petitioners do not fall within the exclusive grounds for Tulfo's disqualification as a candidate for senator. The Second Division noted that the petition for disqualification is not a proper remedy to address the matters raised against Tulfo. Tulfo placed fourth in the 2025 senatorial race, garnering more than 17,100,000 votes. The Commission on Elections has dismissed a petition for disqualification against the Bagong Henerasyon party list. In a document released on Friday, May 23, the Comelec First Division, presided over by Commissioner Aimee Ferrolino, says that it appears that the petitioner allegedly furnished the respondents their respective copies of the petition through registered mail. The document states that the petitioner did not submit an affidavit stating the reasons or circumstances as to why personal service was not feasible. Comelec Resolution No. 9366 specifically states that before the filing of the petition, the petitioner shall furnish a copy of the petition through personal service to the respondent. The document further states that the petitioner also failed to attach a copy of the Certificate of Nomination, Certificate of Acceptance of Nomination. Based on the document, this would have been vital in order to properly verify the necessary information alleged in the petition, such as the name of the party, organization, or coalition, names and respective addresses of the nominees, and other information. According to the Comelec, the Certificate of Nomination, Certificate of Acceptance of Nomination must be submitted in order for the petition to be considered sufficient in form. The Comelec previously suspended the proclamation of Duterte Youth and BH party lists over pending cases against them. The National Maritime Council is gravely concerned over an incident where the China Coast Guard water cannoned and sideswiped a Philippine research ship in the West Philippine Sea. According to the Bureau of Fisheries and Aquatic Resources, two of their ships, BRP Datu Sanday and BRP Datu Pagwaya, were on a routine marine scientific research mission near Pag-asa K2 on Wednesday, May 21. The BIFAR reported that China Coast Guard vessel 21559 water cannoned and sideswiped the BRP Datu Sanday twice, causing damage to its port's bow and smokestack. In a statement, the National Maritime Council says the Philippines expresses grave concern over the recent aggressive actions and unlawful interference of the China Coast Guard against Philippine civilian public vessels in the West Philippine Sea. It adds that while the Philippines' lawful and routine maritime operations have not been provocative, the country's actions have been met by a pattern of coercive actions, unsafe conduct, and blatant disinformation by Chinese maritime forces. According to BIFAR, the incident was the first time that the China Coast Guard used water cannons against the Bureau's research vessels in the Pag-asa case. The Department of Justice has dismissed former President Rodrigo Duterte's complaints against former Interior Secretary Benjo Rabalos and ranking police officials over the search for now-detained televangelist and Kingdom of Jesus Christ leader Apollo Quiboloy in Davao last year. Based on the joint resolution dated May 13, Acting Davao City Prosecutor Angelica Laigo Francisco said the complaints were bereft the essential elements of the crimes of malicious mischief and violation of domicile needed to indict the accused. Aside from Rabalos, the other respondents were Philippine National Police Chief General Romel Marbil, Brigadier General Aligre Martinez, Major General Ronald Oliver Lee, Colonel Edwin Portento, Brigadier General Mark Pespes, Brigadier General Ricardo Layog Jr., Colonel Joselito Clarito, Lieutenant Colonel Israelin Lauren, and John Does. The resolution stated that the records are barren of any factual or legal basis to sustain the prosecution of the respondents for the offenses charged. It added that Duterte's evidence failed to show any crime and actually fall within the realm of lawful performance of duty and are protected by the presumption of regularity in official functions. Duterte filed a complaint as administrator of Kingdom of Jesus Christ properties after around 400 police officers raided the religious group's Glory Mountain compound in Barangay Tamayong in June 2024 in search of Kibuloy. Kibuloy had been ordered arrested for child abuse, sexual abuse, and human trafficking. He was caught in September after a 2-week standoff. Duterte questioned the legality of the search operation dubbed Oblan Parokya and argued it was excessive and unjustified. But the prosecutor explained that under Article 327 of the Revised Penal Code, malicious mischief requires the concurrence of 3 essential elements. These include that the offender deliberately caused damage to the property of another, the act does not constitute arson or other crimes involving destruction, and the act was committed merely for the sake of causing damage or out of hatred, revenge, or other similar motives. According to the resolution, the element of malice in the case is strikingly absent and no evidence has been offered to show that any of the respondents acted with such malicious intent. Furthermore, the resolution explained that the violation of domicile under Article 128 of the Revised Penal Code imposes upon any public officer who is not being authorized by judicial order to enter any dwelling against the will of the owner. The prosecutor said that no evidence was presented that the police or the respondents entered any premises in patent defiance of the law.